It is what it is. All right, so I'm not an attorney, nor care to be an attorney. There is no legal advice on here. There may be opinions, and that's it. If you must need to get an attorney, always seek yourself for an attorney. Okay? I never look straight forward. I always look around. I want to be able to protect myself by any means necessary. Alright? This is a learning video. So take it as a learning video and see if this benefits you. Alright?
Well, Henshaw here again, Constitutional Cook Headquarters. This on the first day of the new term of the 9-0 Parks in Washington, D.C. And they've already summarily denied a petition from Wisconsin.
9-0 Port backstabbers.
Unlucky litigant who relied on a state bar association attorney. A felon in possession of a firearm, and he didn't even commit any kind of a violent crime whatsoever. Defense attorneys are not your friends, people. Get over it. You have to go there and make much better arguments than they either know about and or are willing to make unless they get paid a hell of a lot of money to do it. That's the problem. What do they go up there with? The due process and equal protection of the non-existent 14th Boykin War Amendment. Doesn't exist, never existed. How can you expect to get any remedies there except in the extremely rare case where the just us system has to make it look good? Think Rodney King here in a different context. It doesn't work. You go up there and say, wait just a damn minute. The issue here is that this law enacted by the quote-unquote state of Wisconsin is a bill of attainder.
Okay, I'm going to stop right there just for a second, okay? Everybody keeps on talking about the 14th Amendment, even though it's illegal or legal. It don't really matter, or lawful or unlawful. Okay? The 14th Amendment the 13th Amendment was supposed to free the slaves. Then why did they need the 14th Amendment? Because if they're free, then they are where they are. Just sitting there, think about it, y'all. If the 13th Amendment set the slaves free, why did we need the 14th Amendment? Well, it's because what they did is backlashed it. Okay? The 13th Amendment freed the slaves, but the 14th Amendment brought them back with the illusion of freedom. And it dropped down the original white guys, okay? Down to the same status. So we're still on equal footing. It's just everybody's become slaves now. Okay? And they changed for the black people, they changed their status from being free back into slavery. Okay? And for the people that was constitutional, what you call the white guys and all that, alright, what they did is drop the white guys' status all the way down to be equal footing under the 14th Amendment. Okay? Now, does it always planned out like that? No, they play stupid games. They always have played stupid games. And they're going to keep playing stupid games. And we're the ones that is ignorant of the law and keep playing their games.
Taking of life, liberty, or property without judicial process, and given the fact not only can we prove that Wisconsin's not a state, you can do it in your jurisdiction either too, with the state being a party there. Article 3, Section 2, U.S. Constitution, in all cases a double L, in which the state shall be a party, the Supreme Court has original jurisdiction. The trial should have been in Washington, D.C., not Milwaukee. Accordingly, the trial court never had jurisdiction, even if it got a quote-unquote conviction, aka to the Constitution, as a directed verdict of guilt. And for that reason, even if they could otherwise do it, they can't give an anybody a lifetime ban on owning firearms. Highly questionable anyway. My goodness, it's astounding what they don't learn in law school or what they keep to themselves. I don't know which way it is. But we start answering questions like this, and here the NRA is not your friend either. They have no interest in having issues like this decided. All they plead is the second goddamn amendment, and that's 14th Amendment. They know it. 14th Amendment doesn't exist, has never existed, and you send me an email from my modestly priced constitutional defense document packets at unincourt@gmail.com. You'll get a brief that lays it out and says that the 14th Amendment, the ratification, capital R-A-T, violated all 6 articles of the Constitution. Why are we out there wasting time on BS like this? You get it right the first time. As it says on my business card, by the way, I don't practice law. I do get it right on the first time. That's what we need to start doing. Get away from all this nonsense and get some real decisions. And if in the bargain it puts the NRA out of business, see you later. We don't need you, never have needed you. You're in the fix, behind the scenes with the government, and I'm sure they're paying most of your expenses. So don't be distressed by what just happened today with the 9/0 parts, because you get into their Ashwander doctrine for rules of how they proceed. 297 U.S. 288, page 341. And they say in there that the court will not construe a rule of constitutional law broader than required by the precise facts to which it is addressed. Translation: none of these 14th Amendment cases apply to us. We don't rely on it. We don't need it. It never existed. And we're relying on creator-endowed and alienable rights secured by the Constitution, which the government can't, in fact, mess with. The basic reason being that we're members of the sovereign body politic, derisively known as quote-unquote sovereign citizens. The real relationship, however, here is principal and agent. We tell them what to do, not the other way around. You start, acting that way, and that's what I did in my South Carolina felony case. I shut them up in 30 seconds flat. First appearance I made there after being dragged across the country 2 months in 4 different federal unmarked military aircraft. And you don't have to be near as good as I was about doing it. Either you learn from my documents, send me an email, unincourt@gmail.com, modestly priced up, and you apply yourself like I did over the course of 5 decades and now 15 years all in. And it won't take you near that much time, because my job is to make it relatively easy for you to learn. And with my materials, you get follow-up here. I give you as much TLC via email as possible. You get complimentary phone updates. And I'll even do a complimentary Zoom appearance at a contested hearing. Because I know it's a lot to take in at first. But they don't know on the other side. And often it's not when you put them in this situation where they can't predict the outcome for once. It's not the automatic directed verdict of guilt they're so used to getting. It makes it very uneasy for them, and it should. Because if these bastards are acting, without jurisdiction, legally known as quorum non-judice, even the black-robed bastards are personally liable. They have no quote-unquote judicial immunity to invoke.
Let's just stop there for a second again. The black robe, are held responsible. A few videos ago, I told you guys that anytime to be a judge or any elected officials, they must own land. And then when you become an elected official, then that is their bond. Alright? Just in case they operated outside of the Constitution and trespass upon your inalienable rights. I was thinking a better way of doing it, but it's your inalienable rights. If you did not commit harm to anyone, then they have no business on your inalienable rights. The Constitution is a no trespass sign. You cannot trespass on we the people unless, again, unless I've committed harm upon another man or woman. This is the simplest thing in the whole wide world, and it took me a few years because, at one time I was very ignorant of it, right? It took a couple of times to get stung by the courts to realize some of these things, right? All right.
Astounding bit of legislative domain and what's a legislative tribunal. They don't have any affirmative defenses. See you later. You have a sworn duty to be bound by this Constitution and the laws enacted in pursuance thereof. And when we put it right in your faces, you don't do it. I would love to cross-examine one of these bastards in front of a jury on this. Jury I'm never going to see, and you probably won't either. I have yet to see one in my 5th decade. Civilly, criminally, you name it. Way too much leverage since I'm an ex.
Since you have a right to jury, the courts will not let you have a jury because they don't want the jury to know these things. All right? And in some of these cases, it may be rolled into the private side of courts, okay? You got the public and then you got the private. Again, I heard, one guy talked about basically against what I was talking about, right? However, he said, well, because I'd never seen no case law. Well, when you're operating in my area that I'm learning from, right, there cannot be a case law. Because that goes to the employees, my employees, right? I stand as a man. And since I learned these things, I have not really had the opportunity to use what I do know. Except the one thing. And so far as a year later, or 2 years later, it has not come back. It's been shut down. And even if it did come back, it would still be in a private. There would be no codes and statutes of the paperwork I turned in. It cannot be, because that'd be a witness to the public and to the people that there is things messed up in the system.
Witness, and they can't keep me off the stand to educate the jury. So that's the beauty of it. Also, what I do is help you set an unopposed record in the trial court, because they won't even acknowledge my documents. It's never happened, let alone answer them, and they have the sworn duty to sustain at least the government burden of proof on jurisdiction and venue of the trial court. It's never happened. That's not accidental. You make these arguments, you get a hell of a lot further than you do with civil rights. Attorneys are not your friend.
I really like this guy. But for me, standing as men, I don't go in and argue. Okay? When you argue, you're making claims. But when you make claims, you're giving them some type of jurisdiction. Okay? There's an argument. There's conflict. You cannot go in there and conflict with them, right? You got to set up a remedy for them. And if they don't take it, then you have to do this and they have to do that. So this is it's a process, y'all. It's not like some of these videos I show that lasted 15 minutes. There's a lot of things behind the scenes of paperwork that you got to fill out because you're still dealing with some type of courts. And as you can tell, even with lawsuits, it takes a couple of years going through just a normal everyday routine. You go in there the way I go in there, imagine how that plays out, and then they still got to cover it up.
That said, remember to like the video, subscribe, tell your friends, get the word out. Send me an email for information at youwinnincourt@gmail.com. And the sooner all of us start working together, Asians, Americans, Africans.
I did, by the way, and I hate making this video longer, I did read a couple of posts from people that's got his documents. And he bought a couple of things online, tried to fight these things on his own and all that kind of stuff. And when they got his documents, they actually dismissed his case with prejudice, because he went back in there and said, well, you dismissed this case, but where's the with prejudice, right? You need to make sure on the bottom it's got that on there, because they can come back after you 10 years later. You know, these codes and statutes, they don't have this double jeopardy thing, okay? The double jeopardy is a Constitution thing. When you're in the codes and statutes, legally they can use double jeopardy. Lawfully, they cannot.
The right issues, right court, and right status, the sooner we get these bastards off our back.
Amen, brother. Amen. There you guys go. Pause it. I'm shutting it down. All right. So this is Diesel for We the People News. All right. And the way I do things, it's grueling to learn, because there's really not a whole lot of textbook to stand as a man. Okay. And it's more here recently that people are starting to figure these things out. And I'm sure it's been going on for a while now. But getting in there and do a trial and error thing, right? And kind of understanding the process and how to stay out of the process within the process, right? Because you still got to go to court. And no matter what you do, you're going to have to go to court. But if you do everything correctly and the judge is smart and the attorney, if he's extra smart, he said he's not going to even mess with this and is going to dismiss it before you even go to court. And a lot of times, these things actually do get dismissed in court. When you do an affidavit standing and rebuttals and notices and this, that, here, and there, right? Even if you go to court, the first thing you all need to do is that I'm here on a special appearance. Did you get my affidavit of standing? My affidavit of facts? Well, the judge will say yes. Well, I stand on that. After that, any question you ask, I stand on my affidavit. I stand on all my affidavit and my notices. I stand on it. I stand on it. I stand on it. Every question after that, you don't argue. You just let them know where you're at. Because the rebuttal is the argument. And it's not even an argument. They're just saying, hey, nope, this is not true. Okay? All right. Diesel We the People News. Bye, y'all.